Hi, I'm David Fox, Biotechnology patent attorney in Houston. And I'm a IP attorney in Houston. As an IP attorney, that means I practice intellectual property, ranging from patents to trademarks, copyrights, a wide variety of ways of protecting property that is not necessarily physical, but you protect it in a way that is in a descriptive way. So in this part, we're going to talk a little bit about some miscellaneous intellectual property. That includes copyrights, which really aren't miscellaneous. They're one of the big important forms of intellectual property. There are also provisional patents, design patents, plant patents, trade secrets, and seed conventions, and a number of different ways you can protect different forms of intellectual property. As I mentioned earlier, utility patents are really the meat of patents. Anything else is generally a very thin coverage. First, there are copyrights, and they provide fairly good protection if the infringement is very, very close. And a copyright is literally, you take in a written document and you file it with the Copyright Office at the federal government. They don't look at it, they put it in a file. As we've talked about other situations, if you want to assert infringement, it's up to you to sue somebody. The next patent I've mentioned earlier as well, that is a provisional patent. I would recommend being careful with those because they only provide an earlier filing date, and generally only for non-US countries. They are filed with the Patent Office. They are not examined by the Patent Office. And to be of any effect, you must file a regular utility patent, as we've discussed, and do that within 1 year and claim priority, or the provisional patent is gone and you lose your entire invention. There are design patents, which have sort of an odd functionality relationship with utility patents, because utility patents cover how things work. Design patents are patents that cover not how things work, but what they look like. So it could be the shape of a toaster, but you couldn't claim the heating element of a toaster. They tend to be very thin. And finally, in the patent world, there are plant patents, which are another completely different type of patents. They are examined by the US Patent and Trademark Office. You basically file something and you have a one-line claim. I claim this tree, and you describe the tree, and there's a photo of the tree, and that becomes your patent. And if you find somebody growing a tree just like that, you can assert infringement. There's a very important option available to all of this. Everything I've talked about before involves ultimately a disclosure. There are something called trade secrets, which are basically a way of keeping an invention secret. And there's no limit on how long you can do it or have to do it. On the other hand, if it becomes public at any time, it becomes disclosing of filing a utility patent, and you lose everything. But a good example is the formulation for Coca-Cola. That has been a trade secret forever, and no company has ever been able to figure out the formulation of Coca-Cola. And one more form of intellectual property protection is seed certificates. They're not patents per se, but there are international conventions that protect seeds. There are ways that you can deposit the seeds in a national or international depository, and they will protect the seeds and treat them as if they are a claimed invention. So I think you can see that this is a very complicated topic with a lot of legal issues. I've been doing this for 20 years exclusively, and to me this is second nature. I've been in very large law firms for 10 years and on, and I've recently decided to open my own law firm so I can pay more attention to individual clients. If you want more information, I would be very happy to have a brief free consultation with you. Thank you.